Any mention?
May I please, Your Lordship? I beg to mention item number 5, Lordship.
Yes.
Due to conducting counsel is out of station, that's why, Lordship.
No objection, Your Lordship.
After 2 weeks, Lordship.
2 weeks on the request of the petitioner. Yes.
I do bless, Lordship.
Yeah, please, Your Lordship, I beg to mention item number 8, Lordship.
Yes.
Yeah, I'm praying for 2 weeks' time, Lordship. The counsel for the petitioner is out of station, Lordship.
Who is out of station?
Sheikh, it's a Sheikh.
It's a criminal appeal.
Yes, Lordship. Criminal appeal. Conviction.
And where is the
Yes, Lordship.
accused? He's in.
He's
in
jail,
custody.
Lordship. He's not in custody.
So natural no objection.
Certainly, Your Lordship, yes.
Yes. List after 2 weeks on the request to the appellate.
Apply, Your
Much
Lordship.
obliged, Lordship. May I please, Your Lordship? Your Lordship, I beg to mention item number 3, Your Lordship.
3.
Yes, Your Lordship.
First attempt. Yes.
I've informed the counsel for the other side, Your Lordship. I've informed the counsel for the other side, Your Lordship. They have not reached, Your Lordship. So I pray if this matter can be taken up after 2 weeks, Your Lordship.
This is 2018 matter.
Mr. Nongbri is in this post, Your Lordship, today.
Okay, after 2 weeks on the request of the petitioner. Yes.
Highly obliged, Your Lordship.
May I please, Your Lordship? I beg to mention item number 12, Your Lordship. I pray this matter may come up after 2 weeks, Your Lordship. No objection, Your Lordship.
Okay, also. Just same order after 2 weeks.
Similar prayer for item number 10 and 11, Your Lordship. Similar prayer for item number 10 and 11, Your Lordship.
10 and 11. Then what remains there? Then nothing will. The court will be over by 5 minutes. Very difficult. We do not want to take up cases. Then nothing should be listed then. Who is appearing 10?
Mr. H. Karmi, my lord. I'll be
13. And 13.
10 and 11, Your Lordship.
In both the matters, Mr.
yes,
Karmi.
my lord. H. Karmi.
Okay, this also list after 2 weeks. In the request of the petition.
I
Yes.
do oblige, Lordship.
May it please Your Lordship. Lordship, I beg to make a mention of item number 13, Your Lordship. As the conducting counsel, Mr. A.R. Pasa, has some personal difficulty, Your Lordship.
Item number 13.
13, Your Lordship.
You're mentioning.
On behalf of the petitioner, Your Lordship.
I have no objections, my lord.
This is 2024 matter.
Not
2 weeks.
2 weeks, Lordship.
much more.
13 also 2 weeks. Make it 2 weeks on the request of the petitioner. Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 9.
Item number?
9.
Yes.
But, can make it for 2 weeks time.
Why? Why you want it after 2 weeks?
I'm not ready, Your Lordship, today.
Yes, Mr. Sulai.
Lordship, that issue is still.
Okay. Just number 9 also. Make it 2 weeks on the request of the petition. Yes.
Apply, Your Lordship.
Item number 1.
Yes.
Lordship, I will be appearing in this matter where along with the Guwahati counsel, he is also there.
Yes.
Lordship, first of all, the matter is fixed today for filing reply by the private respondent.
Who is appearing for the private respondent?
By 2 weeks' time.
Suppose to file an objection in this matter.
Your Lordship, in the last 3-4 dates, I have found that they have been seeking adjournment for filing reply. It's a petition under section 482 for quashing the FIR, even, and they haven't filed. And this court, Your Lordship, has already observed while granting the interim bail that the entire matter is of a civil nature. If Your Lordship see the anticipatory bail order at page 19, in which I have appeared, Your Lordship will come to paragraph 4 and 5. The learned additional advocate general, on the other hand, has fairly submitted that a perusal of the said FIR would indicate that the subject matter has the nature of a civil dispute, but has, however, made a prayer for production of the case diary to enable this court to ascertain the extent of investigation therein. This court, after giving due consideration to the submission made and taking note of the contents of the said FIR, would agree with the parties that prima facie it does appear to be a case of civil dispute, for which the parties have an alternate remedy
See,
to take.
it is filing for, there is pending for filing of objection by the private respondent.
Private respondent.
What about the state? You will not be filing, and you still remain. You have still have the same contention, the which was earlier raised on behalf of the state. Anyway, we will just give them.
Your Lordship, my humble prayer is this, that we are getting a lot of harassment from
Well,
the
you are on
police.
bail.
No, he's on the bail. He's on the bail. But point is this: the police time and again is visiting my house, and they have picked up my wife and also arrested her. And I was to take bail from the CDM. And very oftenly they do this. And more so over, out of the same cause of action, same person has lost 2 FIR against the officer of the district council. And they have also come before this honorable court, and this honorable court was pleased to stay the investigation in respect of those 2 cases. And this is also a similar case, Your Lordship. What I suggest, Your Lordship, that case diary may be called, and in the meanwhile, this investigation to be stayed. And when the case diary comes, we can hear the matter finally.
Mr. Jindal, staying this investigation at this stage.
Your Lordship has already stayed
Since
into.
they have taken time, we'll just see. Let them file the objection. You file it by next day. Will not give you. No, will not give you
3-4
much time.
chances have been given to them, Your Lordship.
Yes, Mr. Conley, you wanted to say something.
From the order itself, it is very clear that this sequence between it is from the petition.
So then why do then investigation is in your investigation is in your hand.
Investigation.
You do not require court's order to close the investigation.
No, my lord, the investigation, I believe, my lord, the investigation must have reached a certain extent also. We can also take instruction on that. If at all
You take the instruction. If you do not find, see, the investigation will not be dependent on the view which is, or what about the stand taken by the private respondent.
No, my lord,
If you find there is no case, you
my lord, I will take instruction. Status of the
do it. It is after all the state.
And Your Lordship will find that complainant herein is my elder brother. And he is not even aggrieved. Aggrieved person is a lady who is not present in the Garo Hills.
Complainant is your elder brother.
Lordship.
Complainant is your elder brother.
Elder brother. And he has taken a authority letter from the alleged owner of the land. And on the basis of that authority letter, he has filed this FIR. And there is a police report and which states that the lady who was given the authority letter, despite many notices sent to her, she failed to appear to record of statement under section 161. And entire thing, Your Lordship, Matter may be finally heard, Your Lordship, and case diary be called if Your Lordship is not.
We will just see. Let them objection. We'll just give them while objection, and then we'll just see. File the objection.
It should be as a last chance, Your Lordship, because we have given so many chances, Your Lordship.
You are appealing for the respondent number 2. There are only 2 respondents. Yes, Mr. So-and-so appealing for the respondent number 2. Praise for grant of some more time. Or enabling the respondent number 2 file an objection in the matter. Stop. The prayer has been vehemently opposed by Mr. Jingal, non-its senior counsel. Perusal of the order sheet reveals that the respondent number 2 has taken time on number of occasions for filing an objection, but till date has not filed this one. So, however, for the ends of justice or for the interest of justice, another one opportunity is granted to the respondent number 2 to file his objection. List of appeals.
Lordship, if Your Lordship is pleased to call for a case diary,
Let us see.
just to ascertain.
Let her take the instruction. Let us take the instruction and then we'll just. Causing
After
is
two,
very.
after 2
This
weeks,
stage may not be required also. If they come and then if they say something in your favor, then matter goes. Then it will be on them to challenge it. Because if you go by the submission what has been made by the state council here,
and it is recorded.
they still maintain that there is a dispute between the private parties.
Yes.
So just expect some report will come in your favor
After 2 weeks,
after 2 weeks.
highly.
Item number 2.
I'm deeply obliged.
May I please, Your Lordships? Today I am not ready, my Lord, because I am not feeling well from last 2 days.
This is a king matter, Mr.
No, my Lord. That is for compensation.
Land.
Yes. Next week, my Lord, any date.
No objections, my lord.
See, look at the watch. See behind, Mr. Nothing will remain here. Please go. After a week, on the request made by Mr. H. Hajarka, Council appealing for the state. Was appealing for the petitioner. It's not for the state. Yes.
Much.
Item number 6.
Yes.
Lordship, in this matter, I'm praying for some time, Your Lordship.
That is the same issue, madam, where this appeal lies against the.
Yes, Lordship. It is.
If the appeal lies, then you will have to go there.
The appeal lies before CJIT.
Lordship, I'll take
Is there any period prescribed for filing an appeal?
Lordship, as such, there is no period, but only it is mentioned as in 7I that appeal lies. But Lordship, it has to be. It has to be, Lordship. The amount should the delay should not be prolonged, Lordship.
Is there
because
any mention about that?
No,
Period is not mentioned.
period exactly here in this.
So nowhere it is there, isn't it?
It is not.
So definitely it would be normally if there is no period, then limitation will not
Limitation
come.
act
Principle
applies.
of delay and laches will come. Laches will come. So that will be for that appellate forum to consider.
Consider,
So it is not that they will be remediless.
yes,
It will barred by delay.
Lordship.
You
The
can go and file an
normal.
appeal. You can go and file an appeal.
fix it on Friday, Your Lordship. I'll take instructions.
Lordship, actually what is happening, Lordship, here, this matter, Lordship, it's uh, when audit comes, Lordship, it gets tagged, Lordship. We are stuck with two matters. One is Muda and one is this, Lordship, which was mentioned a little bit earlier also. We are stuck with these two matters because
Muda also is the same
thing, Lordship, because it will go
and
for
they are also appeal lies. There is a
appeal
spree taken by.
lies. Yes, Lordship, and
Why
moreover,
to keep it pending like this?
they are also appeal lies, and moreover, once it gets tagged, Lordship, it is, as a department, we are also in.
Read petition, you know the scope of judicial review. We may not go and go into the merits to decide. Okay, like an appellate authority. Only will be basically concerned with the procedural aspects.
Lordship, I'll take instructions.
Now that is all. You take instruction, but then that is what you should bear in mind. Otherwise, these are matters unnecessarily pending for quite some time. After a week,
Lordship.
please make sure we finish.
Yes, Lordship. Highly obliged.
Item number 7.
After a week on the request of the petitioner. 7. Yes.
Lordship, this matter is with regard to the DPC, delayed payment charges. This is the second round of litigation. When the first round, the matter was referred to Lok Adalat. And after the Lok Adalat was passed, the initial writ petition was disposed of on the basis of the award. So the award was passed where both the parties are to go for settlement. And then COVID came. So both the parties, even though they sat on various numerous of meetings, they could not come to a settlement.
Okay.
Then disconnection notice was issued. Then we came here, and then representation was filed before the respondents. Then we filed this present petition.
That is what the dispute with regard to the amount of bill.
Your Lordship, delayed payment charges, DPC.
Now, who assesses it?
Your Lordship,
Who assesses the
respondents, Your Lordship.
Is there any rule? What
There's a
should be
rule.
the prescribed rate for calculation of delayed payment, the fine?
For that, Your Lordship, we had asked for a breakup as to how did it come to
There
this
is no rule in place.
rule, because it comes up from the respondents, Your Lordship, on the basis of the delayed payment of the electricity bill. Then they come up with a certain amount.
Settle amount, what do you mean by settle amount?
Certain amount, Your Lordship.
Certain amount. Now, what basis that certain amount is calculated? Is there, that is what the court's question is that, say supposing you are assessed to pay a bill of 5,000, you do not pay it in time. And then you make late payment. They say you have made late payment, so you have to pay us 10% or 5% extra. Now that extra, that whether it should be 5% or 10%, on what basis they determine it? Whether there is a prescribed rate for that, or it is the discretion of the officials.
Your Lordship, if you would come to page 238. Annexure 36.
Why such a huge application? What is those documents? Yes, 238, yes.
Your Lordship, if you can see the box here, there's an particulars and amount, outstanding bill, and then next is the DPC charge,
Delayed payment charge.
delayed payment charge.
Now, delayed payment charge, it has been calculated at certain basis, isn't it?
Your Lordship.
What is the rate?
Your Lordship, they just came up with this.
Then say supposing, now you are aggrieved by that, isn't it?
Your Lordship.
Now, if you are aggrieved, you are making a challenge. On what basis you are making a challenge? Do you say it is unreasonable, arbitrary? Is it
Your Lordship, because after the Lok Adalat, after the meetings, the respondent had passed an order where they are waiving 60% of the DPC charge. And then after that, Your Lordship, they implemented this one-time settlement scheme.
Okay.
And then they issued the disconnection notice.
By that settlement scheme, they give you a rebate of 60%.
60%.
Okay. And thereafter they immediately issue it.
Issued.
Who is for the state? Oh, for the respondent.
Yes, our colony, Your Lordship.
Yes.
My lord, I'm not the main assisting counsel in this. I'll just.
No, that is all right, but then if that is the thing, if this rate was reduced by themselves after the settlement, then why the disconnection notice? You agreed to pay that amount. Or did you pay that
We
reduced
agreed
amount?
for a one-time settlement, Your Lordship. After 60% of waiver of DPC, there was a one-time settlement scheme which was introduced by the respondent,
That is for your case only.
Your Lordship. And then subsequently this...
Now, as per that scheme which was introduced,
Your Lordship.
what is the mode and manner of payment? Did you make the payment? Whether your disconnection was subject to that payment or not? This is 2020 matter.
20, Your Lordship.
That state is still disconnected. What you are doing here? If you can run more than 4 years without electricity,
No, Your Lordship.
can
Just
remain there, there is no
recently
problem.
our electricity were disconnected, not for 4 years. Recently, last winter.
Then what made you file this writ petition? What was the cause of action?
Your Lordship, the main reason is because of the DPC. We had filed a representation where we will go for the one-time
Then
settlement.
you say then you had a settled after they assess this rate. Is it not your case that after they assess this rate, you approach them,
Your Lordship.
you sought reduction of that, isn't it? And subsequently after the meeting, it was reduced.
Your Lordship, after that, they never came up as to how much we should pay after the deduction
No,
of
but then
60%.
you said that 60% rebate was given to you.
Your Lordship.
Then that is enough. Then therefore what remains to be said?
Your Lordship, because after this one-time settlement scheme was introduced, we were also never
That scheme was for whom or for
all
everyone?
for all the defaulting companies.
Okay, where is the scheme? Where is your settlement?
There's no settlement, Your Lordship, for that reason.
Then what basis you are saying that they allowed you to allowed you a rebate of 60%?
They did not allow, Your Lordship. They passed an order where 60% of DPC is given to the defaulting companies.
The court did not get anything. Your submission has made the court very confused. Now, you come to page 238, which you have referred. Your outstanding bill is. Sit down, Mr. Renja. You can sit down. Just. Your outstanding bill is 2 crore 42 lakh something, isn't it?
Your Lordship.
And then
DPC is 6
delayed
crores.
payment charges, isn't it?
Yes, Your Lordship.
DPC is delayed payment charge, is it? It is
6 crores.
6 crore something. Now, against that, you filed representation. You approached the.
We approached the respondents.
Yes, then what happened?
They did not accept our representation. They did not
Then
pass
what
any
basis
order.
You say that you got 60% rebate.
Your Lordship, on the basis of the order which was passed by the respondent.
Where is that order? This order is concerning you, or it's a general order?
Page 240, Your Lordship.
Who?
240 and extra 37 is the DPC, the waiver.
$241A.
240, Your Lordship. And extra 37.
Yes. This is 20th August 2020.
Your Lordship.
Now your representation was sometimes in March.
December 2020, 11/12/2020.
Year 238 is on the top. Just see the date, 6/3/2020. Page 238.
240, Your Lordship. 240.
No, that is your representation.
Representation is on page 243A, typed copy.
So what is that 238? What is this page 238? $238 is what? Annexure 36?
238 is the settlement of outstanding bill, Your Lordship.
No. Settlement, it is a request for settlement.
Your Lordship.
It's a settlement or it is request for settlement? Subjects is written settlement, but then it is not. Settlement, if it is settlement, this shall be ordered by the authority concerned.
This we had sent to the respondent, Your Lordship.
That is what, that is your representation.
Your Lordship.
Isn't
And then,
it?
yes, Your Lordship. And then after this,
Yes.
then the order came for 60% waiver of DPC.
Where is that order?
240. page
Yes, waiver of DPC will be allowed in respect of consumers desiring to pay their outstanding dues in installments. Yes. Number 2, isn't it? 240 sub clause A.
Your Lordship.
What is this clause 4 of this page 240?
Your Lordship, page 240.
204, yes, 240. The type copy is 240. There is clause 4.
Your Lordship,
What is the meaning of that?
consumers falling within the category of 2 above will have to first pay the balance amount of the DPC in one installment to be eligible for waiver of 60% of the DPC.
What it would mean? Therefore, when did you write to the concerned authority?
Our first settlement after the Lok Adalat, we wrote on 6/3/2020.
Wait,
where
on
we had,
25th August, this letter came, isn't it?
Your Lordship.
Now, according to that, you are supposed to submit a written request for waiver.
Your Lordship. But Your Lordship, on
Now, after this, did you file any written request for
no,
waiver?
Your Lordship.
Why?
Your Lordship, because the representation which we had filed on March 2020, we had given them this amount where
Your representation was prior to introduction of this scheme.
Your Lordship, we had offered for 36 installment payment of the total
Do
dues.
not go to the mood and things.
But,
Then
Your
right
Lordship,
now, you just tell us, see, your representation was prior to the coming of this scheme.
Order, Your Lordship.
Now, this scheme required that to avail this scheme,
You have to pay 40%.
you have to submit a written request. Did you do it?
But Your Lordship, before that,
Whether you did it or not,
no,
you tell us, have you done it?
no, Your Lordship.
So
Because
you want to say that the representation which you have filed before, that should suffice, that should serve a purpose.
Your Lordship, because we offered 36 installments to
Doesn't
pay the
matter.
total dues and they never replied to our representation then.
See whether they reply or they do not reply as per your offer, that is up to them. But then once they introduce a scheme, and thereafter if you apply in accordance with the scheme, then there definitely duty is cast upon them to reply. Now the question of the court is that whether after this coming of the scheme, did you file an application? You see, whether they accept your proposal or not, that is up to them. Okay, we cannot force them to accept it. At least you do not have a enforceable legal right to seek that from the court. Okay, so long you do not dispute the amount. If you say that the very assessment of the delayed payment charges was not in accordance to the norms, then we can examine it. But then that is not your case. Your only thing is that the amount of such and such, thereafter a scheme came. Under that scheme, if you make it one-time payment, then 100% waiver of the delayed payment. And if you prefer to pay on installment basis, then 60%. But then the scheme says that for availing the benefits of the scheme, you have to file one written application. Now, first you have to show us that you have filed a written application, and then you show us why they have rejected it or what they have said, what they have responded. If you want that they are bound to give a response, then you must show that you file an application thereafter. Yes, Mr. Renja, can you, or you are not there, you will not be able to say. Any idea about the procedure, what this electricity board adopts for recovery of the amount?
My apologies, I don't have
You do not have any.
information.
Do you have any idea how they do it?
Your Lordship.
The recovery of the amount, how they do it, dues. Say supposing you do not pay, even after disconnection you keep mum, how they recover the amount?
Lordship.
No idea. It must be provided somewhere, some rules.
In the Act, it must be there, Lordship. But the Act also says, Your Lordship, if DPC is pending for more than 2 years, the respondents cannot
Claim it.
recover.
It will barred.
It'll be
Where
barred.
is that provision?
As per the Electricity Act, Lordship, the Act is,
Okay. So there is a provision.
there's a provision, Your Lordship.
Then what remains with you to pay the principal?
Exactly, Your Lordship.
Then pay it. Have you paid it?
No, Your Lordship.
Then if you do not pay it, then how you can seek restoration of the connection?
Lordship, because the last representation which we have filed, we did not get any
Not needed.
communication
If
from
you
them.
say that it is barred, time barred, then why you want your representation to be considered? That becomes your legal right.
Lordship, then I'll do some more research in this matter.
There is no research. You are not at all prepared. And your reply says, yes, madam.
My lord, we are waiting for instruction from my friend, my lord.
What instruction?
They have, in one of the occasion, my lord, they have sought permission from his honorable court. They will be filing a serious manner. They'll take.
No, they have said long back, because they said that connection has not been restored. That was done long back.
So, my lord, if they are not filing any such,
They will not file anything. It was a verbal sort of instruction. What is the situation?
My lord, if they wouldn't,
Because what this court notices that the writ petition was filed almost 4 years back. Now, if any disconnection was made 4 years back, whether party still
no, my lord, there
is
was no
continuing.
disconnection so far as my knowledge comes. There was no disconnection.
Yes, there is no disconnection in
There
this
is-
In
case.
fact, there was a penalty bill also imposed.
Penalty
which
means
was-
this delayed payment charges.
My lord, there was non-payment of the bill, my lord. So another writ petition was also filed by
You
them
come this
for
just
restoration.
change. Do not keep him in between.
There was a restoration on that bill, and then on the basis that the petition will be paying the the regular bills, that case was also disposed of. This is the old case, in which subsistent extra amounts were they challenged the amount they have raised, my lord. And more or less, this case should have been.
Court did not get anything.
My lord,
This
actually,
is a petition. What is the prayer in this petition?
they're challenging, my lord, the penalty bill, my lord.
What is penalty? Is it
No,
late
but-
payment? The charge which you levy as delayed payment.
My lord, delayed
This is-
payment.
Do you call it penalty?
My lord,
No, what is penalty?
Penalty payment, delay payment, my lord, maybe the term may not be
If you
actually
say
correct.
penalty, what she referred just now, she said that delayed payment charges. You are saying penalty. Now court must understand what is what.
My lord, delay payment will be the correct word.
So that is why, see, if you make submission like this, court will be confused. Now see, our contention here is that because of delayed payment, some charges were levied.
My lord,
Now against that, they filed a representation. Now during the pendency of their representation, one scheme came. The electricity board formulated one scheme, and as per the scheme, it said that if anyone makes one-time payment of the outstanding bill, then there will be no levy of delayed payment charges. And then it said if somebody wants to pay it on installment basis,
there was an understanding from both
then
parties.
there will be a 60%. Now, her contention is that thereafter, she has not been made known anything. Nothing has been communicated to her. She says that as per the scheme, she is entitled to get it. Okay.
My lord,
Now, what is your stand in this case? What stand you have taken in this case? In this present matter, what stand you have taken?
my lord, I'm not in a position to apprise this court briefly, my lord. My apologies. Because we will.
How do you recover the outstanding amounts from a party?
Outstanding amount, my lord, with
Just supposing somebody doesn't pay, even after your demand also doesn't pay, then how do you recover it?
my lord, I would be. It may be quite dicey for me to speak right now, because certain time what happened, there are times and again in which the parties sit together and their kind of settlement and arrangements are being made.
If it is not
That-
happened,
that in-
say supposing party doesn't respond to you. She doesn't pay it.
My lord, the only
She
option
runs
which we have
away.
is
She
disconnection.
runs
my lord.
away. She goes back. Then she doesn't pay. And then after a few days, somebody comes and applies for a fresh connection.
The immediate consequence is disconnection, my lord, and subsequently
That is all
recovery is
right.
a
We are
different
not on
procedure,
the
my
core
lord.
question is that how do you recover it?
My lord, there is a procedure. There is a procedure, my lord. We
You
have
say
a
like you
standard
will not be
procedure,
able to tell it right now, isn't it?
my lord.
Now what happens? What the court will decide when the lawyers appear without instruction?
My lord, we were on the impression because
We'll
from
toss
the
a coin
last
and see head and tail and who.
because my lord, what we were in the impression, if there's something coming up from their side, we will see what can be done, and therefore this matter. In fact, my lord, in one of the
She
occasion,
has referred to a representation which was filed by them.
my lord, I'm not aware of the representation.
What is that? Page 238 in the writ petition. Just see.
We have already filed our counter affidavit, my lord. We should have replied to this also, my lord.
Why?
My
What
humble
you have said in your counter affidavit?
My lord, I do not have the brief right
So then,
now.
if you do not know how she will reply,
No, my lord, we have filed because my lord, we have filed counter affidavit twice in these cases.
that
In
is
this
all right.
particular
What is
one.
your stand in the
So I
counter
believe,
affidavit?
my lord, we have counter to this particular notice also.
You have countered it.
Lordship,
And then what
if
did you say?
my lord, my prayer is
See, Miss Colony, you do not finish the things. You are running very fast.
my
Court
lord,
cannot catch you.
my lord, my only difficulty today is we were in the impression if they would file, if they would bring some instruction as they have prayed for the last three occasions.
See,
If something is not
on the last
coming,
occasion, what this court remembers is that when this matter came up, the court was informed that the electricity connection was disconnected. Okay. Now, realizing that this writ petition was filed
2020.
4 years back, and there is a considerable lapse of time, by normal understanding, we can say that a person will not be able to run without power for
My lord, I believe
long
it is
time.
incorrect.
So, because of that, we just wanted to know what is the situation. That is what, nothing more than that.
If so, my lord, this matter can come up tomorrow, my lord. If my friend is not coming with any instruction, we can have this matter
Tomorrow, sure, we can dispose it off. We will
My
come
lord,
with all the
I'll
instructions.
prepare, and I believe my colleague who is actually handling this, he will also be there. He was only on the impression that there will be something coming up today, some materials will be given to us, therefore we can have this matter on the next
Is there
occasion.
anything reflected like
So
that?
if they are not doing, my lord, we
Is there
can have this
anything?
matter.
Why don't you go by the last order? Why this court should believe your say until
can have this
unless
matter,
that
my
is
lord,
provided
tomorrow.
in this order to the court? Let us see what is there in the orders of the court. Last date was a flat adjournment. No, there was a real representation was rejected, madam.
Lordship.
Hmm? You file an affidavit to bring on record that factum of rejection of your representation. Then there was a prayer by the respondent to file fresh affidavit. Then affidavit was filed. Then it was for you to supply a correct copy of the affidavit.
We have done that, madam.
I've done that.
there is an order that no further adjournment will be allowed, and then thereafter also adjournment is allowed. None of the parties point out all those orders passed by the court.
My lord,
This court has passed an order that no further adjournment will be allowed, and now thereafter again a court
the
has gone
senior
on
counsel
adjournment.
appeared, my lord. He make a submission that some instruction will be required.
Nowhere
Latest
it is there.
instruction.
It is nowhere it is there. You should point out to us.
Your Lordship, on 16/4/2024, we had asked them for instructions.
See, you see 6th March, Apple asked for some time for taking instruction with regard to the latest status. Next day, nobody appeared.
Then, Your Lordship, on the last day, 3/5, we had apprised the court that,
You are supposed to take some instruction.
Your Lordship, instructions as whether we are still pursuing the matter or not, since the electricity has been disconnected. And on the last day, 3/5, we had apprised the court, Your Lordship, that we will go ahead with the matter.
No, on the last day it was a flat adjournment. There's nothing at least in the order sheet to say it. So your instruction is that you will proceed ahead with the case. There is a disconnection. This is something should not be done by these courts. You see, nowadays the problem is that once councils make joint prayer also, you have to look at the order sheet. And that is difficult. This court itself contradicts its own order. On the last occasion also it happened. Of course, that time first set of order was passed by one court, but then it becomes lawyer's duty to point out this is something very wrong. MSB Karwandam, another counsel appearing for the petitioner submits on instruction that the matter has not been settled and the electricity connection of the petitioner has been disconnected. She submits that petitioner is keen to pursue this. Petitioner is keen to pursue this matter. Give a full stop. Madam, what shall we say?
My lord.
She has given her instruction. You say that she has not been settled.
My lord, we can have this matter on positive fixed hearing, my lord, on the next date, because that is the only reason for which the matter was pending for the last 3 dates.
Just say. Stop. Ms. R. Karni, learning counseling, appearing for the respondent. There is that the matter may be finally heard. In the next week. When?
My lord, my colleagues will be on VC. It is for them, my lord, because senior counsel is leading this matter.
When shall we list it?
1 week, my lord, no objection.
After a week?
After a week, my lord. I have no objection, lord. She can have this after a week. It is for the petition.
After her submission, we can proceed with the matter today also. But then you say that...
Tomorrow, my lord, that was my submission. We can have this matter tomorrow.
Tomorrow we do not know what is there and what is not there. And if it is tomorrow, then again a supplementary call has to come.
My lord.
So we'll have it after a week.
My lord.
What we said? Just last line, Ms. R. Karuni. Stay, submits, not praise. Submits that the matter can be finally heard and praise that the matter may be listed after a week. Prayer allowed, list after a week. We'll have it next week.
Highly obliged.
If you come prepared, you see, there may not be, see, these these matters, I don't think any serious question of law is involved. Okay, so only you have to see what you are entitled to. So if you have a definite set of instruction, then probably we can decide. You do not need senior to do these things. You can do by yourself. Finish.